तो तय करेगी कौन इंटेलिजेंट है। चीफ जस्टिस ने यह भी कहा कि कोई कोर्ट ये कर ही नहीं सकती, हमारा काम आईनी खला पुर करने का नहीं होना चाहिए। चीफ जस्टिस काजी फाइज ईसा ने कहा, हम सिर्फ ये देख सकते हैं कानून साजी आइन के मुताबिक है या नहीं।
इसका मतलब है कि अगर कोई डिक्लेरेशन हो, डिस्पाइट दैट डिक्लेरेशन द इलेक्शन कमीशन कैन अनडू दैट डिक्लेरेशन।
No, the election commission, for example, disregards that declaration.
Yes.
Then a person can come before your lordships or in the High Court under 199 go on to and say that here is a declaration.
The validity of the declaration issued by court of law.
Yes. So declaration is not the validity which can be questioned by the election commission or by the speaker or a chairman in that case. If they come to the conclusion that this declaration is actually not 62(1)(f) declaration. This is perhaps for an offence or something which is not covered.
Mr. Mansoor, you've landed us in a bit of a more problem here. So the question was earlier that we were going along with whatever semblance of a declaration was given by Samiullah or civil litigation, original civil litigation. We thought we'll take that declaration and then play around with the duration period. Here the question is that there is no declaration, and that's not really a declaration. And Isagha Kwani raises that question. Nobody has addressed it head on as to what could be such a declaration, and that declaration probably requires some serious thought from the Parliament. So where does that leave us now?
So, my lord, what that leaves to your leaves you, the declaration so far given, people might come in due course to the courts that these declarations were not declarations by a court of law.
कल कोई और पार्लियामेंट से आकर कह सकते हैं कि ना अहली ताहयात हो, फिर क्या होगा? चीफ जस्टिस ऐसा कह रहे हैं।
Position of whatever that court is for the time being. I would say I cannot give this declaration. Why? Take away your suit, take away your plane, take away whatever you want to do. I cannot do this. I mean, I cannot go into your hearts and determine what sort of human being you are.
That's right.
So taking that question further, what do we do with the constitutional provision now?
So what happened here?
Say it's unworkable. Wait till the Parliament decides.
My friend,
इसका भी जवाब आसान जवाब है, बहुत आसान जवाब है। इसका बहुत आसान जवाब है, जो लोग कॉन्स्टिट्यूशन बनाने के माहिरीन थे, उनमें ज्यादा अकल और दानिश थी, उन्होंने 73 का आइन बना दिया। और उन्होंने एक साहब टहलते हुए आए, उन्होंने कहा हो कहीं ये लोग सर ना खड़ा कर लें, तो ऐसी चीजें डाल दो इसमें कि हर कोई जो मेरी मर्जी हो मैं उसको डिस्क्वालीफाई कर सकूं। अभी इस बात को हम क्यों नहीं कह रहे हैं, इसको बात का एतराफ क्यों नहीं कर रहे हैं? तो समीउल्लाह बलूच स्पेसिफिकली मेंशंस दैट इट वाज इनकॉर्पोरेटेड बाय इन द ड्यूरिंग मिलिट्री टेकओवर।
बिल्कुल बिल्कुल।
So I mean
the revival of constitution,
I don't know why we so
1985, but 18th amendment
we go into the niceties of grammar and English and we are forgetting the overall picture.
18th amendment. The problem is that
18th amendment भी वही मसला है ना कि इधर आपने देख लिया क्या हालत हुई थी पाकिस्तान में, वो भी हम क्यों नहीं बात कर रहे हैं उस बात की? जरा सी उन्होंने लैंग्वेज बदल दी तो उन्होंने पता नहीं पूरा पाकिस्तान came to stand still. We must realize that there are issues which are exploited for personal ulterior motives.
My lord,
gain certain political advantages. Now, once we are not a court of law that we should shy, we are not that we should shy away. We are a court of law, upholding the Constitution of Pakistan. Constitution does not, rightly or wrongly, does not provide a time period. Why should I fill in what the Constitution has intentionally left, even if I accept it at par with every other constitutional provision, something brought in by a military dictator? भाई उन्होंने नहीं किया, वो जाने, मैं क्यों काम उनका करूं? नहीं, आपको जरूरी करना है। क्यों? भाई देखें, absence is also a decision. If I don't decide to do something, I'm deciding something. Parliament has elected to remain, leave it aside. We also leave it aside.
My lord,
अगर वो कल कोई कानून साजी करेंगे हम देख लेंगे उसको।
Mubashir Hassan case में my friend Ahmed Qayyum read out paragraph 115 from Mubashir Hassan, where the full court held that 62 is not a self-executory provision. 62(1)(f) is not a self-executory provision.
And they were judges थे?
Sir, it was a full court. It was, I believe, 15 or 17. Full court थी sir.
What context was that?
So they were looking at examining 62(1)(f because it was NRO which was under challenge. NRO under challenge था, तो उसको वो देख रहे थे, and उसमें 62 को उन्होंने examine किया 62(1)(f को, and they went on to hold that it is not a self-executory provision, and by that, I think it doesn't explain it in that detail, but perhaps the rationale behind that was that because there is a declaration by a court of law which is required, then there is a law or several laws must also provide some mechanism how that declaration is to then come out.
I mean,
now, what has happened here is that 232(2) provides a time frame for the longevity of that declaration, but it does not then address the 4 questions which were left open by.
I mean, this constitutional silence has really got us.
नहीं sir, अब आप उसका ये कर सकते हैं. Options here. Either you leave it to the parliament.
Yeah.
Elections are around the corner. Leave it to the parliament.
Till then, what is the status of this provision?
So this provision is, as the Supreme Court held, is not a self-executory provision. It requires making a law. The law has to be made. And that is for the parliament to do.
नहीं, अगर ये इन्होंने वर्डिंग लिखी है स्पेसिफिकली, मैं मुबश्शिर हसन देख रहा हूँ. मुबश्शिर हसन में जरा गिनते हैं 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 17
पैराग्राफ 115.
हाँ, 115 में 17 जजेस हैं, यानी कि फुल कोर्ट. It is true that अच्छा. The provisions of Article 62 of the Constitution cannot be pressed into service because it is a provision of Constitution which is not self-executory. तो ये तो फिर बुनियाद ही उड़ा देता है बाकी जजमेंट्स की. इससे अगर मैं डिसएग्री करना चाहूँ, मैं कर ही नहीं सकता हूँ, क्योंकि अगर हम सारे जजेस भी बैठ जाएं फिर भी हम 17 नहीं बनेंगे.
Did Ishaq Hakwani look at this?
Ishaq Hakwani did not, I think.
Ishaq Hakwani probably realized
Ishaq Hakwani was perhaps
अच्छे सवाल हैं, मगर इनका जवाब नहीं मिल सकता.
But Ishaq Hakwani would have, if it had gone on to examine it, I think this question would have come. Or that because this provision actually requires making of a law by the parliament to give effect to this.
There is a reference to a judgment, Muhammad Afzal versus...
This is Raja Muhammad Afzal versus Muhammad Altaf Hussain, sir. 1986, 1736, it said that...
Finding तो आती है.
That judgment said that it's a declaration.
I think this has clarified something.
Mubashir Hassan said puts an end to it.
Is a definite finding.
It's an innate provision.
Yeah. So as D, E and G, for example, now they operate on their own, perhaps more so an appeal to the electorate.
Yeah, then they
F also is an appeal to the electorate.
After this finding, they just join the family of the rest. You see, D, E and G. They all become nice inspirational guidelines that we must have a parliament like this.
Yeah.
That's it.
That's it. And if we have an appropriate law providing for how that declaration would have to come forth, it is
ताहयात नाअहली केस की समाअत इस वक्त जारी है, जिसमें अहम रिमार्क्स भी सामने आ रहे हैं और समाअत का अहवाल आप तक पहुंचा रहे हैं. चीफ जस्टिस काजी फाइज ईसा की जानिब से ये रिमार्क्स दिए गए. अदालतें कानून नहीं बनाती, अदालतें सिर्फ पार्लियामेंट के बनाए कानून का जायजा ले सकती हैं.
It does provide for the duration part. It does not provide for the procedure and manner.
Mubashir Hassan was mentioned or no?
No, I don't imagine, sir. I did not come across more.
कि मुबशिर हसन में कहा है कि विच इज़ नॉट सेल्फ एग्जीक्यूटरी, ठीक है. बट अब समीउल्लाह में अगर हम देखते हैं, समीउल्लाह में उन्होंने कहा कि सिविल कोर्ट का जजमेंट होना चाहिए, तो उन्होंने भी सेल्फ एग्जीक्यूटरी तो नहीं कहा है. उन्होंने भी कहा है कि जजमेंट होना चाहिए सिविल कोर्ट का. देयर मस्ट बी सम डिक्लेरेशन बाय द सिविल कोर्ट.
ये उन्होंने कहा, और ये उन्होंने जरूर कहा, और ये अल्ताफ ये उन्होंने जरूर कहा कि जी डिक्लेरेशन होना चाहिए. एंड परहैप्स ये
पढ़े ना, जरा वापस आइए,
एक रीडिंग
114 पे आए, पैराग्राफ पेज 423 ऑफ मुबशिर
जी, उसकी एक रीडिंग ये हो सकती है.
नहीं, वो पढ़ेगा. इट इज ट्रू, जरा देखें उसमें, तो फिर आगे वो कह रहे हैं पैराग्राफ 114 का लास्ट जो है, इट इज नॉट दैट सेल्फ एक्सिक्यूट